because yesterday we set a strong foundation of water protection and connection. Today we continue with more conversation, learning, and the work of building shared streams moving forward. My name is Brittany Harlow, and I am co-founder of Crosswinds News and our parent company, Talking Circle, both Muskogee citizen-owned and based in Tulsa. It's my honor to guide us through today's sessions. So thank you again to everyone who traveled to be here and all who are contributing to these important discussions. Raise your hand if you were here yesterday. Awesome. Raise your hand if today's your first day. Wow, that's a good mix. Well, I'm sorry for everyone who today is their first day, because yesterday everyone got some raffle tickets. And today, those people now get to have two raffle tickets if they haven't won. So, if you haven't raised your hand, well, if you have your raffle ticket still, take a couple minutes to track those down. Sorry. Do you have the roll? All right, so if you throw your raffle ticket away from yesterday, raise your hand and Trista will give you a new one. And if you arrived today and you haven't got a raffle ticket, then great. Keep your hands raised and Trista's going to make their own, because we're going to kick this event off right with a raffle. And not just any raffle, but a big one. So thank you for waking up early. This is our morning way to kick it off. So it's donated to us graciously from Osage Casino.
Did anyone not get a raffle ticket?
Keep those hands high so Trista can find you. Not replacing. If you were here yesterday, you do get 2 chances to win. So keep those hands high. Okay. Hands high. Keep them up till Trista finds you.
I'm just going to hold it.
Trista, are these from today? Everyone's streaming, that's why you need to be here in person. Show that beautiful table. Alright. Yes. Alrighty, guys.
Remember, you gotta share it with me. Hey.
I told everyone when they walked in, when I gave them their ticket, you gotta share your prize with me.
More.
Oh.
This is for, what is it? Mug? Pendleton mug?
Okay. Alrighty. So these are going to be the last 4 digits of the ticket. 7881. Okay, going once. 7881. Okay. Alrighty, here we go again. Okay. Okay, I was like, this one's fell off. Okay. Alrighty, last 4 digits. 7954. Anyone? No? Okay. Oh, there we go. Alright, here we go. Okay. 7931. Oh, hey. Thank you very much, Trista. There will be plenty more throughout the day. 1, 2, 3, 12 more. So, plenty more chances to win today. All right, to kick off today's program, we are honored to welcome Professor Alex Pearl from the University of Oklahoma School of Law. Professor Pearl is a leading scholar on Indigenous water law, sovereignty, and the future of tribal rights in Oklahoma. Joining him in conversation is author and educator Chelsea Hicks. Together, they will discuss water law, Indigenous rights, and Oklahoma's evolving legal landscape. Please join me in welcoming Professor Alex Pearl and Chelsea Hicks.
Okay, we're going to have a riveting conversation about water rights and law, and it's so exciting. And so we're just getting to know Mr. Pearl here, and so just to start, I want to ask you if you can just tell us a little bit about your experiences with water rights as a lawyer, and perhaps some of what you've learned from your experiences and a little of what you've done in this area.
So I just want to say thank you for the invitation to be here today. I love that this is a conversation about water, that is dedicated to water. And there are few resources, especially in Indian country, that I think can generate such a multitude of conversations and opinions and views and viewpoints. So I think this is an amazing event. So I'm grateful to be here. I started work in a Washington, D.C. law firm when I was finishing a federal clerkship, and I went to go work in D.C. with a law firm that practiced in Indian country because that was the only way that I wanted to practice law. I wanted to go and represent my community. I'm a citizen of the Chickasaw Nation, and that was what felt right to me. And so I was a philosophy major in undergrad, so like I didn't know, and I was not an environmental science major. I didn't know anything about hydrology. I knew nothing about this, but I knew about sovereignty and I knew about the law a little bit. And so I started work there, and one of the issues that I was tasked with researching and writing about dealt with a tribe in California's claimed rights to groundwater on their reservation. And so what I didn't realize at the time is how novel that case was, in how tribes should think about where they can assert their rights to water, to what resources that would attach, how they navigate dealing with counties and states, what court you file. It's just a whole multitude of things. But what I loved about it is interacting with the tribe and thinking about how they view their water and how they viewed their neighbors using their water. And so that's really where I started. I knew I wanted to work in Indian country, and water was not something I had any idea about, but it's what nobody else did. And so they said, well, you're youngest, so you go figure it out. And so I did.
That must have been really exciting and stressful. Very stressful. So when I start trying to apprehend just a little about what establishing rights might mean, one of the things that Principal Chief Jeffrey Standing Bear brought up in a conversation about that is the Winters Doctrine. And I'm wondering if you could talk about that a little bit, just to speak a little of what rights do tribes have and ways of establishing them.
So the Winters Doctrine is named that because of a Supreme Court case in the early 1900s. In that case, there was a tribe in Montana that wanted to start using water for agricultural purposes and a variety of purposes. They had not really substantially used the water in any significant way for irrigated agriculture or anything like that. But there were significant ranching communities there that had been watering cattle for thousands and thousands of heads of cattle, so a significant amount of water. And so there was a conflict between the amount of water that was in the river and who is going to have access to it. Is it the tribe that has been there since time immemorial, but whose reservation was only established relatively recently? Or is it the ranching communities that have been there technically prior to the establishment of the reservation? Obviously, they're not prior to the tribal community that's been there. And so there was a question as to who is a court going to recognize the right in. Typically in the West, and the way water rights works, it's that you have to demonstrate that you're using the water productively for a valid use, and the amount that you need to use it is the quantity that you're entitled to. Now we have a permit system that you have to fill out a permit for everything. But that's typically how we think about that in the West, is through this, what we call the prior appropriation doctrine. Now, that presented a problem, at least on its face, for the tribe, because the tribe had not, at that point in time, engaged in any significant agricultural use or significant water use. And so you could argue, well, they have not used it. The ranching families have been using it first, and so they get the right. Now, that's not what the court decided. So, in the court, in ruling for the tribe and saying the tribe has the prior right, the court said, when we look at the reservation, what was the purpose that it was established? Why did they create this reservation? And it's the same purpose for every tribal reservation, is to create a permanent homeland. Whether that is established and stated specifically in a treaty, or an executive order, or in a statute, however the tribe's reservation is created. They're created to be a permanent homeland. And so what the court said is, the tribe is entitled to the amount of water necessary to fulfill the purpose of the reservation, to create it as a permanent homeland. So then the question is, well, how much water is that? Now, the other thing that's really important about the Winters case is that in the creation of the tribe's reservation, it did not specifically say, and we're going to reserve the water. All it said was, we're reserving the land. And so what the court did with that is said, well, of course, we have to imply that there is a water right in addition to the land reservation, or else the land reservation doesn't mean anything. It's worthless. If you get to land with the water, it's worthless. It certainly can't be a homeland. which is the purpose of the reservation. So that was a groundbreaking case. First time it had ever been construed that way. And it's a really important case for tribal sovereignty because the federal court recognizes that the tribe has more rights than is specifically laid out in the statute or treaty or executive order. And that's really important. So that's the Winters Doctrine. So basically, if the tribe has a reservation, they have this Winters right, and they have the ability to sue to enforce and quantify that right.
It gives me two questions. One is, I guess, to check in on the reservation status for Osage Nation, because I know some claim hither and some claim thither. But also, I just have this question popping into my head, and I don't know if there's any kind of alternative, like if the young you was coming up now and they said, oh, why don't you go just claim all these rights and have the tribes in Oklahoma just take over water and replace the state? Like, is there any fantasy like that? I don't know if you can answer that.
So I love that. So on the status of the Osage Reservation, there may be folks in the room that have a more up-to-date understanding than I do. But this, as I understand it, in January of this year, Council for the Tribe filed a motion to have the Northern District of Oklahoma Federal Court reconsider the Irby case, the Irby decision, which said, curiously, that's the way I'll phrase it, curiously, the Osage Reservation has been disestablished. Now, that was a decision prior to the McGirt decision, and McGirt really changed the way we think about the test for when a court is assessing whether a reservation borders have been disestablished. And so the motion that the Tribes Council has just recently filed, and again, that's where my knowledge stops, is to say, well, the Irby decision is inconsistent with what McGirt requires courts to do. And the federal court needs to reconsider the Irby decision on that ground. There's no question in my mind, from a legal perspective, that the test that Irby ran to assess reservation boundaries is inconsistent with McGirt. Now, whether the court grants relief or not, I don't know. But that's my understanding. And then we've got a state court opinion from Oklahoma State Court in a criminal case, that's how the McGirt borders question typically comes up, has basically said, without really any deep analysis, Irby says the Osage borders are disestablished, therefore we're just going to copy and paste, basically. So that's where I understand the present status is. It is in limbo. So that's where that's at. Now, in terms of is there a future where tribal communities and tribal governments take a more leading role in regulating and controlling water resources? My answer to that is always yes. There is absolutely that future. For the simple fact that Congress has significant authority to change who gets to do what in terms of regulating water resources. The question of who has jurisdiction over controlling and regulating water resources, in general, it is the states. Now, if it's an interstate water source, like the Mississippi River or the Arkansas River or something that traverses most states, or more than one state, that makes it absolutely subject to congressional oversight. And so Congress can pass a statute that says, this water source is now, here's how it's going to be regulated differently. Alternatively, there's the possibility that tribes could assert sovereignty over the water resources that are located within their reservation boundaries. That's an expression of civil jurisdiction, which becomes more complicated and more difficult, which we may talk about later, but I'll stop there. But yes, it is possible. There is a possibility there for tribes to have a greater role, a greater say in regulating those resources.
Okay, so I want to go into like a scenario where you said that was called civil jurisdiction, where the tribe tries to have more rights over what's our own.
Right.
So, according to these pamphlets that I got last night from the Choctaw Nation, and I know I've heard, it said that as Osage, we have certain sort of like things we're proud of as a tribe, but sometimes I think Choctaw is one of the tribes I've heard talked about as, oh, they're so powerful. I don't know if we could be like them. But anyway, just small disclosure, but please consider with me for a moment. According to these pamphlets of the Choctaw Nation, the policy, I'm going to read for a minute. The policy of the Choctaw Nation with water is that no water leaves their basin without their approval. They are developing a hydrologic model to validate that. They have created water permitting processes as per their tribal government. Surface water requirements, groundwater requirements, water settlement agreements, and more. And looking at Osage Nation Code, there are mentions of water within certain scenarios that pertain to some of what I just mentioned, but there's, I think it's a growing area, if I can have a hot take with room for more. And is that an example of, or what would be like the highest possibilities of sovereign water right reclamation in a case like that? And then with the interstate, if it's not too much to ask all at once, with the interstate waterways, I know that we have a situation with the Brewer case in the Arkansas River that I don't think the Osage have looked into kind of reclaiming those rights. So I guess the question is just, can you say a little bit more about what rights would look like?
So part of, I think, where the Choctaw Nation is seeking to enforce its own tribal laws in that context stems from the water settlement agreement that the Choctaw Nation, my tribe, the Chickasaw Nation, and the state of Oklahoma entered into regarding the water resources that are within those communities. Now, it is, those are oftentimes better outcomes, right? When you have multiple parties, tribes in the state that are working together. I mean, I think that we have all seen, not just recently, and not just in Oklahoma, how challenging it can be when you don't have a willing dance partner in whether it's criminal jurisdiction, public safety, water resources, whatever it is, right? Gaming, right? That's a partnership that tribes engage with the state. We always get better outcomes through partnerships, but you've got to have a willing dance partner. So part of that settlement agreement was initiated or influenced by the presence of a water rights Winters style litigation. And so, one thing that is true about water rights litigation in a Winters style is that it will take forever. It will outlast the lives of the attorneys that probably filed the case. So they are not quick adjudications for lots of reasons that are so technical we would absolutely put everyone to sleep. But part of the objective in a water rights litigation, in a Winters adjudication, it might not be to win the lawsuit. It might be to get the state to take you seriously so that they will come and negotiate with you in good faith. Here's the real challenge with a tribe seeking to quantify water rights or to acquire a water right, to have some recognition that this is your water. You could do that through litigation in Winters. And at the end of that litigation, if you win, What you have is an order, a judicial decree that says, here is your water that you're entitled to, and after the quantification phase happens, here's the amount that you're entitled to. What that order doesn't include is any money that it might require to actually build the infrastructure, pipelines, plants, whatever, to actually access the water. And so then the tribe has to either come up with those funds itself or seek assistance from Congress or the BIA or otherwise. And so we call those paper rights, that they exist on paper, but there's no water that's going to your house or for the agriculture or for whatever other uses you want it to. Alternatively, if you file the winter's action, if the state needs some coaxing to take you seriously and to be a partner, then what you do is you come up with a settlement agreement, which is what the Chickasaw and Choctaw nations in the state of Oklahoma did. And then you ask Congress to pass that settlement agreement into a statute. Now, what Congress can also do at that point in time is include funding for infrastructure, right, to help ensure that tribal governments, tribal citizens have access to the water and can actually get it. We call that, in the most annoying redundancy, wet water. So what's, I know it's ridiculous. So now it is ridiculous, the whole thing's ridiculous. But it's a negotiation, it's a settlement agreement. And so what happens oftentimes is the tribes will give up some portion of what in an ideal world you might be able to recover under in litigation, right? Which you're, depending on the tribe's position, right, you would be willing to give that up for certainty, for infrastructure payments, and for other things, right? Or regulatory authority over the water. And so that's part of what is important to understand about the water settlement for those tribes is the tribal leaders from Chickasaw and Choctaw have always said, we want a seat at the table to say where our water goes. We don't want it going to Dallas. We want it staying in our communities. Or if it's going to go to Dallas, we want to have a time limit on how much and how often, that sort of thing. And in my view, that is an expression of sovereignty, a say-so in what happens and do we have a chance to voice our opinion.
Okay, so using this metaphor of using our voice, speaking up, getting the attention of the state, one scenario that I think of is the state kind of initially laughing us off as, ha ha ha, you little oil tribe, how dare you say you want water? And I know that right now people are kind of speaking up and resisting a data center on our Osage reservation area, if we can, if we can keep arguing for it to be that. And then I've also heard that in terms of sustainable energy field diversification, one thing people are looking into is geothermal. I know that our Minerals Council has been asking for years, how can we diversify? So I guess my question would be, what do you see as like our potential to be involved in sustainability-like things? And maybe we could talk about the data center in particular, and maybe ask what does it look like to partner with other maybe local entities on resisting a data center, and could we possibly sort of sovereignly do something to use our voice against the data center if the people are wanting to speak out against that?
So one of the things that's true about data centers is they're going to increase in demand, right? Like that is where that's going, and there is a significant interest by most federal policymakers on both sides to build more and more of them to compete with other international players. So that is the new world. So every time you use ChatGPT, that is why. Like that's why that's happening. And most data centers, although there's new technology now, most data centers need water to cool them. And they use a lot of water. I don't know whether they use chemicals, but I know that there are some emerging technologies that use different methods to cool the data centers so that they're not using fresh water, right? Now, certainly, if the tribe is a landowner, right? If it's on tribal trust land or tribal fee land, the tribe absolutely can apply its own laws there, regardless of whether it's an Osage citizen that wants to do something there or some other non-Osage tribal member or a non-Indian. If they're on Osage trust land or Osage fee-owned land, Osage sovereignty carries the day. Now, if it's still within the reservation, again, asterisk on, is it still the reservation? But it is non-Indian owned fee land, Osage Nation sovereignty is much more limited. That comes from a case called Montana, which establishes this rule that presumes that tribes lack civil jurisdiction over non-Indian owned fee land on the reservation. So fee land just means like if you bought your house on the open market, like that's fee. Fee means the federal government doesn't have a trust interest. And so in that circumstance, it's up to the actual owner to say, I don't want a data center here, or you've got to make sure it's the newer version that doesn't use as much water. Those sorts of things. Now, on tribal trust land, the Osage can say, they can set the rules, right? They can regulate that because it's their property. And I think that when we're looking at industries that are highly water consumptive, if you were to ask ChatGPT this, it would say to you, irrigated agriculture is the #1 most intensive water user in the United States, and that's absolutely true. Now, hydraulic fracturing is another one that's highly water intensive. Data centers are another one that's highly water intensive. Now, if you were to look nationally, you would see that those latter two are just a sliver of the pie chart of like freshwater usage, and like 80% of freshwater usage is irrigated agriculture. It is huge. But if you were to drill down away from the United States and just look at like county by county, if the county has significant fracturing industries or significant data center industries, you're going to get a very different pie chart because those types of industry are significantly consumptive for water usage. And the other thing that's challenging for data centers is that the water usage there is largely evaporative, which means it's not produced water, it goes into the atmosphere. So with fracturing, you get produced water, which can sometimes be cleaned and then reused for other things, or gray water, something like that. But with data centers, it's not that way. So, I think that part of the assessment here for tribal communities is, what kind of world do we want to live in? How do we want to run our community? And that's not an easy question, and that's for your elected officials to make a determination of. Because at the same time that we want to be protectors, right, and keepers of the water, there is an economic component to life and a revenue-raising component to existing. And those are political decisions that the tribes are able to make given their sovereign status. And that's what we fight about at Chickasaw, that's what every tribal community, that's what every state community, it's just politics, right? About what we should value and what we should put our efforts and money towards.
You just have me imagining all of us downloaded onto the cloud and becoming a bot because there's no more water. But trying to get back to this question. So you mentioned with the property law and the fee land, it seems like it would be good to understand and review, how does property law affect tribal reclamation of water rights, as well as how do the surface rights, like those ranchers you were mentioning earlier, how does that affect and play into the ability to reclaim rights?
So there's a growing movement, land back movement, and that takes a number of different forms. And of course, people will disagree on whether something is actually land back if it is not the absolute return of the fee interest to the tribe and then reestablishing a contiguous relationship, basically undoing allotment, right? As a former Cobell attorney, like the problem of fractionation is a significant problem, right? So that is the goal, I think, for every Native person. I've not yet once met a Native person that was like, I don't really care about reacquiring land for the reservation. Like, I think that we all agree on that. I think we all agree on that. I think so. Now that makes everything like jurisdictionally, in terms of regulation, that makes it easier, right? Now, the challenging thing about, in particular Osage, but other reservations that have been both allotted and had this mineral estate severed, is that adds a layer of complexity to who has jurisdictional authority to regulate this, that, and the other. But I do think that we don't need to think about land back as a binary. Either it's fee land that the non-Indian or the state owns, even though it's on a reservation, or it is our land held in trust, part of the reservation. And I think that the interim steps can be expressed through partnerships and collaborations, like co-management of resources, right? Like if there is, I've seen this happen a lot in other areas of the country where you have an alignment of interest between a tribe and, say, sport fishermen, right? Folks that like to go fly fishing in rivers. In order to do that, there have to be fish. And in order for there to be fish, there has to be enough water in the river that allows for them to populate and continue to thrive. And in order for there to be enough water in the river, that means that we have to be mindful of how much irrigated agriculture we're allowing to happen in the area, or whether we allow hydroelectric dams to be in the area. And so, even if we don't have a transfer of property rights and title to the tribe can be a partner in managing a resource that everyone has an interest in protecting. And so I think that that has been, now that I'm in my mid-40s, I'm like, let's collaborate and be a partner. When I was 26, absolutely, all the time, right? But having lost a lot of wars and pissed a lot of people off so that they wouldn't want to work with me anymore, I have grown up a little bit.
How dare you put it that way? Okay, let's get you guys in on your lots of brilliant questions. And yes, Shannon Shaw Duty, let me pass you over. Okay.
So we watched this wonderful documentary last night called Drowned Land, and it was, it was great. One of the things that really stuck out to me was their not only did they, win the day with the Oklahoma Water Resources Board, but now they are moving toward an expression of sovereignty, of rights of nature, giving their river personhood. So how does one do that?
So it's a great question. I love this idea. For those of you that haven't seen the film or are not sure about what that means, so the phrase is rights of personhood. that some communities have conferred that status on non-human things like rivers or wild rice or other organisms and structures. Okay? Now, why do that, you might ask? Well, when something has the status of personhood, it can be injured. And it can be injured in a way that brings with it a whole host of legal doctrines that allow the sovereign entity greater protective capacity over an injury to a person rather than an injury to a thing. And so it demands a reframing of, I think, your median American understanding of what it means to be a person. And that's hard for some folks to get to. And there have been our Indigenous relatives in New Zealand have done this with the river as part of a treaty that they signed to recognize that personhood status of the river. And they actually established a board that functioned as a trustee to ensure that the river is protected. They can't speak for themselves, and so there are people that are designated as guardians to do that. And they file litigation on behalf of people that injure the river. We would call that pollution, right, or overconsumption. But then if it's a person, we call it an injury. And there's a different legal standard that comes with proving up that there was an injury. Now, in the United States, I'm familiar with two tribal communities that have utilized this rights of personhood status over different resources. One is wild rice at the White Earth community, or White Earth Ojibwe community, to designate that as personhood status, to protect that resource. The other is the Klamath River in Northern California and the Yurok community. Has anybody heard about this, the Yurok community in this tour before? So, Amy Bowers Cordalis is a Yurok tribe member, and Chelsea, we were talking about this last night, that I had the good fortune of overlapping in law school with her for a semester. She's a Yurok tribal member, and she's a lawyer, and she went home to the Yurok reservation, which straddles a portion of the Klamath River. They are a salmon people culturally. That is where they understand their identity and their cosmology, their reality, their who they are. And there are a number of hydroelectric dams that are upstream that obviously provide, power to the communities in Northern California, but also make it very difficult for salmon to pocket. And so it also reduces the water level in the river such that the water temperature is too hot so that the salmon cannot propagate. So you can have all the fish ladders you want to make sure they get through the dam. Doesn't matter because they're dying because the water's too hot. And so she has been on, since I've known her as a second-year law student for 20 years, this has been her focus and her emphasis on trying to fix and reclaim the Klamath River for the salmon, for their relatives. And she is victorious. Like, the dams have been taken down. And so when I hear stories like that, I can't help but feel hopeful about what's possible, whatever's possible. All of Indian country has sustained so much challenges and difficulty. I'm a believer in that. So one of the first things that she did is that she worked with her tribal council when she was Attorney General there to establish an ordinance that was passed unanimously by the tribal council that said the Klamath River now has the rights of personhood status. So it's just a tribal law. It's just a tribal ordinance. And that can take a number of different forms, right, depending on whether the tribe uses codes or ordinance system or statutes or whatever. But it's a tribal law, and that allows them to think about the river differently in the context of on the reservation with respect to the tribe's laws now. The limitation on that goes back to the enforceability of civil jurisdiction over non-Indians. So if you have a non-Indian person that is doing something in the river that they should not be doing, we have a challenge in how are we going to be able to enforce that, right? Criminally, no. Civilly, maybe. But even if it's not enforceable all the time against non-Indians, there's still value in it. Because, I'm going to be a little philosophical. Yes. Law is the expression of a community's will, especially in the criminal space. We designate these things as important, as problematic, as protectable, as whatever. The Indian Child Welfare Act, that is the expression of the community's will, right? Establishing personhood status for a resource is the expression of the will of the people. I can't think of anything more important than that. So symbolically, I think it's important, and it certainly can get everybody in the community on the same page about how we're going to treat this, right? How we're going to designate and communicate to our elected officials that this is that important, that we're all on board, that we'll all make sacrifices to make sure that this resource is preserved.
We have time for a few more questions, and just, that's making me, what you said is making me think of our language. And Wilena Fields had our project, Witsikomi, Ishtakia, bless yourself with grandfather, son. And our languages have that in it, that it's not a thing, it's a person. Witsikomi, my grandfather's son. And so as we're revitalizing our language, I think we might be down, possibly, a little. Yes, okay, over here to Ms. Gigi Siki, and then, yes.
Hi, I'm actually taking a sovereignty policy and law class at the University of Oklahoma with Dr. Mel Fillmore. And so this is kind of going along with what I've learned in that class and also my ideology with the Osage Nation. So the Osage Nation, we have everything under the topsoil. That is something different between us and other tribes. And so if anything is being built, you have to kind of alert our Minerals Council in order to kind of get approval. And we have filed a lawsuit against the windmills out kind of going towards Fairfax, towards Ponca City. So we have had, legal cases with this. And I know that we are a nation state. We do have the right to sue. We do have the right to act as a nation, as a state. And I know that AI laws haven't been truly established with the Senate, with the state of Oklahoma. What can we do as a sovereign nation to push for more regulations with these AI companies coming in, building on our waters, because now we're going into that territory of we're going to be able to reclaim the water. I hope that's the process that the Osage Nation is doing, because we're talking about it. This is something that's important, especially for my generation, because I know AI is not going away. I even use ChatGPT. Sorry, professors, but I'm being very honest. As a journalism student, we are now being taught to learn AI, figure out AI, work with AI, because the possibility of AI taking our jobs is somewhat slim, but once they develop that personality and anything can happen. So I'd like to hear your thought on that.
Thank you for that. Also, shout out Mel Fillmore. She's awesome at the University of Oklahoma. So one of the things that I think is really important to understand, right, is that if anyone wants to do something on Osage Tribal Trust land, they have to get your permission. And if there is a gap in Osage code or regulation that doesn't require something getting the right in order to protect the water, or you can't use this much water or something else. That is a gap that can be filled. Now, some of the concern or the reason why data centers and other AI-related infrastructure has been promoted for especially rural communities is, well, it brings jobs. And I am not a politician, but when I have talked to people that have had these in their communities, the jobs are construction jobs that are temporary. And a lot of times the people that work at the data center, there's not that many. And a lot of times the people are outsourced and they're brought in. And so there's not a sustained investment by the company in the community. And look, that's a thing that the Osage Nation can require, right? You're the boss. You can require whatever you want, right? Now, of course, the other side of that is the more stuff you require, the less likely private parties are to come and build things here. And maybe that's the point. And if that's the point, then great, right? But it is about this remembering and utilizing that sovereignty. My thing that I always say is that sovereignty is a verb, even though I know the word is not a verb. I know. English proof I know. But if it's dormant, what are we doing? What have our ancestors been fighting for? Like, why are we not doing this? So that's, and you're right, that this is your future just as much as anyone else's. And I think conversations like this and like this 2-day symposium on water is fantastic to elevate the level of understanding and information about all of these issues.
Good morning. Thank you for coming and having this, being a part of this discussion. I'm trying to figure out how to encapsulate this question. It's kind of multifaceted. So we have multiple things going on. Like you spoke on something about Osage trust and restricted land and Osage fee land. Right? And you talked about jurisdiction being over those things, but not non-Indian fee land. The one thing that, like, you know, lit a light bulb in my head was you said Osage fee land. Is that Osage, and then I'm thinking, okay, our laws, how do we exercise our sovereignty? What are we over, right? Because a lot of our Osage families and people have lost their allotments, right? But they're still living here. For whatever reason, they lost their land through, we all know. But they're still living within the boundaries of what I still like to call Osage Nation reservation, right? So there are people like Bill Sim and these people that always push back on the idea, this is where I live. But then you have these communities like Gray Horse, Pawnee Indian Village, Pawhuska Indian Village, and that trust. And it's like, it's only applied to that. But the Osage Nation, as the government, can own land, and we're always putting it into trust, right? So that we have these certain benefits. However, you included the word fee. So what about an Osage tribal member? It's a member of the Osage Nation that has land within the boundaries of Osage Nation reservation. Like, has that been explored? Have you seen anything within court cases that exercises sovereignty over our own? And there may be Osage like, I don't want anybody telling me what we're going to do with my land. But at the end of the day, this is our home, and it's hopefully our home for, into perpetuity. So there's that. And then how do we, if we go that route, what type of, is that a collaborative government side? Is that a person's, like, what do we do? One. The second thing is they talk about, this one's kind of touchy, is compacting our minerals. That was a huge discussion this last session, correct? And I am for sovereignty. I'm for our Osage people being in charge of the things that we have, right? Not opposed to that. However, what I'm afraid of is something similar to what people were talking about yesterday with the marijuana plants. There are no laws in place to protect our communities. So they said they approved it without the laws in place to prohibit all this stuff. So one of the things that when I had talked to some of our Congress people, for it, what Osage laws are out there or in place to protect our landowners, to protect our communities, because we're all living here. So if those laws aren't in place, what are we doing? And a lot of people will say, well, we don't need to pass those type of laws because it's only on restricted land. Well, it's not going to cover everybody. And I'm like, you got to start somewhere. And if you're going to regulate our water, our minerals, or any of that, what state laws are in place to protect us, to protect our communities, to protect our individual landowners, whether they are restricted or non-restricted? Because they're still Osage tribal members. Not only are Osage tribal members, but the people that are living within our communities. So, thank you. And any insight you have.
Thank you very much. So, good questions there. The first one that I heard is, if you're an Osage tribal member, but you own fee land, does the tribe have jurisdiction over you, right? Like to say, you gotta cut your lawn, it's too, or whatever, like a zoning requirement, something like that.
We have criminal,
Right.
Not in Osage Nation, but other tribes have the criminal side of that.
Absolutely, right? And
So
again,
where does that?
the criminal part of that is if it's a tribal member within the reservation, yes, the tribe has jurisdiction. Now, again, that's the question about the status of the Osage Reservation, which is under current law, based on my understanding, it's been disestablished because of Herbie, but there's the asterisk on Herbie. Now, if it's on trust land, that's different, right? Restricted status land, that's different. The tribe still has jurisdiction over that because of the nature of the land. When I teach criminal jurisdiction in my Indian law class, I did it 2 weeks ago, there's literally a chart of like, if Indian, victim, and, right? Like, it's crazy. Right, it's very difficult for sheriffs, FBI, PAA, tribal police. It's very difficult. It can be very difficult. But there are some tribes that assert very strongly that if you are a tribal member or you are an Indian non-member, right, living on the reservation, you don't care what your land status is. We have jurisdiction over you. They can't do that for non-Indians. But certain tribes will say, yes, we're going to choose to regulate you. We're going to assert that right. Now, the person being regulated will then challenge that and say, in tribal court, no, you don't. And then we argue about it, right? And then so that outcome can vary from tribe to tribe based on how that tribal court has interpreted their own tribal laws and sovereignty, but also the limitations expressed in federal law. So there's that. With regard to there being this gap, right, of, well, we don't have any laws in the books that protect the water or, require a showing that it won't do any harm to the water before construction begins or something like that. All of that can become technical, right, really quickly. And that means that we've got to have some expertise or some reasoned view of why we're requiring X, Y, or Z. What other tribes have done is, in part, by reference to tribal customary law or personhood status ordinances. Now, the way that some tribes have utilized their tribal, what I will call tribal customary law, which is typically expressed in their own indigenous language, that is trying to fill in the gaps that inevitably exist when you have legislatures writing statutes, right? They're not going to think of things. Things will arrive, right? Things will develop technologically that they will not have been able to foresee. And so what tribal courts can do under that circumstance, or tribal legislative officers, they can say, well, we don't have a law requiring us to do, to require, some sort of agricultural farm, marijuana farm to make a showing that they won't use this much water. We don't have that law. What we do have is Osage customary law, for example, that says we have to be the guardians and protectors of the resources, and we think that's water, and so therefore you have to show us, consistent with our understanding of Osage customary law, that you're not going to do any damage to this. So it's really not anything different in the United States or the state side. We have state statutes, we have state codes, we also have state common law, which is judge-made law that changes over time. We have the same in the federal context, right? And so I think that tribes have that ability, right? The Navajo Nation's court decisions, they're fascinating. I teach some of them in my class, that they will give a reasoned opinion of the legal issue in English, and then in the last part of the opinion, they will say the rest of this we have stated in Dene, because we can't express it in any other way. Now, if you're a non-Indian, you're thinking, how is this fair? I don't know what's happened, but there is this English part of the opinion, right? But I think that there are options for tribes to amplify and animate that customary law to fill in the gaps of codes and statutory provisions, if that makes sense for the community. But it's a good question, right? I mean, how to develop a significant regulatory state, that's a lot of time and money and expertise. And there's a way to do it by reference to...
Where would you recommend the Osage Nation current legislators go or to seek information on creating these laws and regulations? Because, some of them don't have that background.
Sure, yeah.
So it's like, we need this.
Yeah.
Where do we go? Who do we go to get
Yeah.
those experts to help us draft legislation so we have laws on the books?
Yeah. Yeah. I mean, sure, but who was the young woman here that spoke earlier? Yeah, she sounds like she's got some research skills that she could go and think about tribal court systems. Or come to law school. Hey, let's chat. Let's talk. But no, it's a good point. I mean, ostensibly, there should be universities that have long-standing partnerships with the Osage Nation that should be interested and willing to help, like University of Oklahoma. So I would love to be a part of that conversation if there's a way for OU in research capacity to assist with you. Does anybody know Tana Fitzpatrick from OU? She's amazing. She's also a lawyer. So I'd be happy to further that conversation as to how, OU can be a partner in some ways.
We got one more question back here.
Thank you, Helen. Really glad to have you here. A lot of good information. And back to the data centers, that's what everybody seems to be talking about right now. And what if it comes down to a court case or an injunction or whatever needs to be done? Is that going to be up to what I've been hearing is that they're going to be using a lot of water. Is that correct?
That's my understanding of most data centers.
So, if, as you know, we talked earlier, about the 1906 Allotment Act, and everybody's got different allotments. And if there's Osage allottees on that particular area, 900 acres, one understand. Is that going to be up to them, or is it going to be up to the Mineral Council, or the Osage Nation Congress, or the chief, or is it going to be up to the Water Board of Oklahoma? Is it going to be decided there, or could it go all the way to Washington, D.C.?
Great question. I don't know that I can artfully punt this question, but I'm going to try. So I think that there are a couple of different facets to the construction of a data center. One is the physical construction of the facility. And if that is happening on restricted status land, tribal trust land, there are going to be BIA and Osage reservation regulations that are going to apply to that. So that's point one. Now, if it's depending upon how much water it's going to be using, right, and whether that water is considered state water, such that it would require a permit and a right in order to extract that water from whatever the resource is, whether it's groundwater or surface water. This state may have a say in that too. Now that's a circumstance where, as Chelsea and I were talking earlier, tribes don't typically have that authority unless there is a settlement or some statute that says, yes, tribes can permit the water on the reservation. So there may be a role for the state to play in that context. I'm just not sure, based on where it's going to be located and how we would conceptualize the usage of the water necessary for the data center, whether the state of Oklahoma is going to have regulatory approval over that or not. But the first question is, whose land is it going to be on? That's the first question.
Alex Pearl, please put your hands together.
Thank you, Professor Pearl, and also thank you, Chelsea, for that powerful conversation. Let's give it up one more time for both of you.